Zachary C. Ashby at Pacific Northwest Family Law. Wanted to do a quick video regarding the rule of evidence we come across in court a lot. Because a lot of people ask us, so what can we say and what can't we when we do motions or we go to trial? What's allowed to be entered in the court? What can we use? That's a much more complex question. Really, you should share all the information. If you have an attorney, you should share all with your attorney, because sometimes, even if it's not allowed in the courtroom, your attorney can find a way to, it might lead to stuff that is allowed in the courtroom, or otherwise it might lead you to, your attorney might be able to find a way to bring it in. And we're going to talk about one of the more complex evidence rules. It's called hearsay. First off, I'm going to use my high-tech visual aids here. Hearsay is an out-of-court statement offered to provide the truth of the matter asserted. So there's a few things that we focus on as attorneys when we're talking about what's allowed and what's not in the courtroom. One is that's an out-of-court statement. That means it happened outside the courtroom with people who aren't there, can't be cross-examined, you can't follow up with them. This is different than if you bring a witness in maybe and you ask them what they saw or what they heard or what they witnessed, because this is something that a witness told you. And so now you're trying to relay that to the court. Well, that probably won't be admissible under most circumstances. Although you should share that with your attorney, and maybe you can strategize a way to bring it in under some of the things that we're going to talk about. Now, the hearsay rule has a long history, and there's a lot of exceptions, so I'm just going to hit some of the highlights for you. The other is that that there is a matter asserted, and that it's offered to prove that. The proof of the matter asserted. So there's three big parts that we focus on as attorneys when we're arguing for or against the acceptance of a piece of information. Now, some examples, big examples that we see in family court of hearsay is a statement from a child, for example. Children, when it comes to kids in family law, it's really hard to get their testimony in front of the court. So we find that some people want to include a statement in like a declaration or in a witness statement or something, but this is hearsay because the child's not there in the courtroom. The child's not making the statement to a judge or anyone that matters. So what we have is, one example that we come across is, my son said the opposing party uses drugs. Well, that's not admissible. It's not provable. So you can't use that to prove that the opposing party uses drugs. You just can't do it. Now, another thing that we see often in the family courts is that like a witness to something is trying to told you something, and you're trying to relay, well, I heard this happened. You can even name the person, give exact details and everything. So things a witness tells you is, so the opposing party's neighbor told me, right, that they do drugs together. Well, that's still not, since it's the opposing party's neighbor saying it, then that's still not admissible to prove that the opposing party does drugs. So that won't work. Another one that surprises people are police reports. I think that's just barely on there. Police reports are not, they're out-of-court statements made by a police officer about what happened. So you cannot use the police report to prove that what's in the report actually happened. And there's other circumstances. So often the way that we get around this is that we, especially in a trial, we have the police officer come in and testify, and they get cross-examined and things like that. So that evidence might still be there, or it will lead to name other witnesses to an event that we can then use. Other forms of hearsay would include documents like emails or text messages or letters. All of that is potentially hearsay if it's an out of court statement used to prove the truth of the matter asserted, right? So all of those things I would probably try and keep out, especially if it harm my client. And the reason is that those statements are hard to disprove or hard to test for their validity, because they're made by someone who isn't there. You can't examine the statement. You don't know exactly what was in their head or what they meant by it. And so those statements are kept out. And the other reason is that you have a right to confront your accuser. So if someone is accusing you of wrongdoing, you should be able to confront them and say, what do you mean? What do you mean we were doing drugs together? I'd never do drugs, or something like that. Or that we call chocolate cake and ice cream are drugs because we're teetotalers. So it can, something like that can be taken out of context. And so that's why hearsay is left out. Now, some examples of things that are not hearsay that are important to know if you're trying to get something, and ways that we can get things in. If it's a question is different from an assertion. So if your child comes to you and says, "Daddy, does mommy do drugs?" Oh, the child isn't saying that mommy does drugs. The child is asking a question. Well, that might be able to come in for evidence for certain purposes. Also, statements of the opposing party, because they are technically in court with you, and they can respond and explain themselves and give context, or if you're accused of something, same thing. If you set it out of court, it's probably going to end up in court. So that's why we always counsel our clients to be very careful about their communications, that they should consider before they shoot off an angry text or something, because their words can and will be used against them in a court of law, with dire consequences sometimes when we're talking about family court, because it might mean less time with your child, or it might mean a smaller division of the assets, or something catastrophic because you blew your top and started saying things that you oughtn't to have said. And then the other thing is that it's off. The other one is that it's offered for a different purpose than to prove that it's the matter, other than to prove the matter asserted. So in that example before, when the neighbor tells you, "Oh, we do drugs together," that could be used instead to show something, not to prove that the opposing party does drugs with the neighbor, but to show that maybe that's their reputation, or that that's what they're known in the area. Or a police report might not be used to show that the things that are in the report actually happened, but that the police were called to the scene and that there was an arrest made, or it's a record, and so the things that are in the report may or may not have happened. That's not the point of why you're presenting it. The point of why you're presenting it is to show that the police became involved, period. And so those are some of the ways that you can use the hearsay rule to your advantage or disadvantage. So again, all these things, the hearsay rule, it can trip up even experienced attorneys. It's important to understand what the contours are of that rule, and really to consult someone who's been trained in it and its use. So if you have more questions on this, or what is or was not allowed in court, go ahead and comment to this, or send us an email at info@pnwfamilylaw.com. Or if you think we can help you otherwise, you can also call us at 509-866-4111.